of course, another mistake is failure to prepare any will. If you don't prepare a will, of course, the state has a will prepared for you in its statutes, and it's typically a will that you wouldn't write if you were left to your own devices. It's a legislative attempt to be fair to surviving spouse and to children. The next estate is inappropriate reliance on simple wills. Now we've talked about a simple will and how it works and how it can create some tax issues. And we also talked about if you do a simple will, you're missing out on an opportunity perhaps to protect assets from the creditors of the surviving beneficiaries or to protect the assets from long-term care costs. The next mistake has to do with who will be carrying out the instructions that you leave in the will. Too often, people provide detailed instructions in their will and they don't give enough thought to who's going to carry out those instructions. Now, the person who carries out those instructions, that's the executor. When the will is admitted to probate, that means that somebody's applied to the probate court to make a determination that this document actually is the last will and testament. And when the court does that, the court appoints an executor, the person who's supposed to carry out those instructions. And when the executor is appointed, it comes with the power to collect the assets of the decedent and to use the assets to pay the bills and expenses, to pay debts, to deal with taxes, to sell property, and to make the distributions to the beneficiaries. And it can be a complicated job. One reason why we like to do these estate planning seminars, and we also do an estate settlement seminar, is so that people have an understanding of what the executor's job is and can make a more informed decision about who that should be. And we talked about trustees. Now, the executor's job is more short term. It's to make sense of the puzzle that any decedent leaves behind and collect the assets and clear things up, pay the bills and the debts and the taxes and the expenses. And pretty much when that's over, hand the assets over to the beneficiaries. And one of the ways that done is sometimes handing it over to a trustee of a trust. We've talked about trustees and trusts a bit before, so you have a good idea of what that means. But the trustee's job, keep in mind, is one of management, investment, keeping in touch with the beneficiaries, and it could potentially be long term. And people oftentimes think about individuals as trustees. Usually they'll look to family members first. It's not every family member or family that has a member that fits the profile of an ideal trustee. If your family has a person like that, that can be a good selection. Sometimes they'll run through the list of family members and they'll think, I really don't have somebody who knows enough about investing or finding good investment help, or taxes or finding good tax help, or accounting and finding good accounting help. All those things are needed when it comes to the management of a trust. And if they think that there's not the right person in the family, they might look to a trusted advisor that they've known for a long time. It could be a lawyer, it could be an accountant, and they'll look to those types of people. And if they don't have those types of people, they start thinking about banks and trust companies, which can be a very good choice as well. Sometimes people are reluctant to do that. That's too bad, because banks and trust companies that are in this business have a good deal of experience and expertise when it comes to management of assets and investments and keeping track of beneficiaries' needs. Oftentimes, a good way to do it is to name a bank or trust company together with an individual, making them co-trustees so that the bank or trust company can take care of business matters, and the individual can be the one who's more inclined to stay in touch with the personal needs of the beneficiaries. And of course, when the client is young, they might have young children, and the appointment of a guardian for the young children is very important. And we find oftentimes young couples have trouble agreeing on that, and that's one reason their wills don't get done. But it's much better to to name somebody than to leave the selection for argument or guesswork after your death. So the guardian's job is to look after the personal needs of the children, make sure that they have adequate, shelter and education and training and health care and all of those types of things that a parent typically takes care of. And if there are any assets that go to the minor, then the guardian's job also is to take care of the assets. There actually can be guardian of the person and there can be guardian of the estate. There can be two different hats to wear. That's a very important part of a will for people who have younger beneficiaries. Another mistake is failure to adequately plan for cash needs. Now, just imagine after you pass away, there will be debts, there might be taxes, you might have back income taxes on your individual income tax return. There will be income taxes for the estate to take care of and file returns for. And if there's a trust, there'll be income tax returns for the trust. And then there's estate taxes. Those are the death taxes that we've been talking about. There are expenses to pay, the funeral expenses and probate court expenses, attorneys and accountants fees, the executor's fee, all of those types of things. And then, of course, you may be the breadwinner and people may be counting on you for their support, but once you're gone, your income is also gone. And that might create a cash need if you want to provide proper support for your survivors. People who have businesses frequently don't plan adequately for the succession of their business management and control, or to sell the business. So it's important for people whose businesses are a large part of their estate to take care of that part of their estate planning. There's another tax that we haven't mentioned until now, and it's called the generation skipping tax. And I won't take up too much time with it, but whenever your will establishes a trust and there's potential for that trust to pass down to younger generations, that's a generation that's younger than the generation that's right under you, there's potential for a generation skipping tax. And we like to make certain that our wills include provisions that allow the executor and the trustees to make decisions to minimize or avoid that tax as much as possible. And there's a lot of powers that you can give to them in the way of allocating a thing called a generation skipping tax exemption to those types of trusts. And so we like to make certain that our wills include those types of powers. We've talked about some of the mistakes, and one of the mistakes involved retirement plan accounts. More about retirement plan accounts in our next segment.